Hi, everyone. Good to see you all. Today's live session, we're really going to focus on the 75 countries that got banned and added to the list. And this plays into a much bigger picture with what the White House is doing, with what USCIS is doing, and how it plays into everything that we've seen in the past year. It ties into the Trump card, it ties into the 100,000 H-1B fee, it ties into so many things that we're going to dive into today. So it is not just a pure travel ban like what we have seen in the first administration. There's so much more that we want to talk about. So today's news segment is going to be a little bit more in depth, a little bit more learning. Hopefully you guys stick with me while we go through that. Like always, feel free to ask questions. I'm here to help answer anything and everything that I can. And then the second part is where we talk about the success story, and it's a success story of a H-1B self-petition, right? It is a self-startup petition. Started their own company, 100% owned by the beneficiary, petition, transfer, and come to the U.S. So it's a very, and I didn't purposely put these two together, but as this news came out, as we're diving into it, we see the connection. So we'll tie into that in a little bit. But first, let me talk a little bit about the 75 country ban. The main and core idea of it is that this administration is saying these 75 countries essentially too poor. How can we let them into the United States? Essentially, they are a public charge. They're going to revisit the public charge adjudication process of the consulates and to determine if they are going to be essentially taking U.S. benefits. And we are seeing countries like Egypt and even Russia that's a part of this. So we're going to dive into this. Now, the first thing we want to talk about is just a clear distinction between this and the 19 countries, right? And because the 19 country ban that came in a couple months ago, not a couple months ago, just a month ago, it feels like it's been a quarter already. That's a full benefit ban, which is much more extensive. You can't become a citizen, you can't get non-immigrant visas, you can't get a lot of things, right? If you're part of 19 countries. So it's super strict, and that applies corely with USCIS in the United States. But this 75 country ban is at the consulate level, meaning if you are applying for a non-immigrant visa, that's fine. If you get approved, you can still come to the US. We'll talk a little bit more about that later on and why a lot more people will be doing that. But this is a consulate ban, meaning let's say you are a parent petitioning a child, or you are a US citizen brother petitioning a sister, right? And they waited decades. They paid all the filing fees. You proved everything. It got approved by United States Immigration Services. And now finally, after 6 months, you go to the interview, you pass the interview, but because of this new pause, you don't get that immigrant visa in your passport, and you cannot fly into the US, and you cannot get your green card. You've paid all the fees, you waited all the time, everything got approved, but now because of this new policy in determining, hey, let's re-adjudicate whether or not you're rich enough, whether or not you are wealthy enough, whether you will potentially become a public charge to the United States, where the United States taxpayers have to support you, let's re-evaluate that. And then everything is paused. All immigrant visas. We're talking about business immigration visas. We're talking about family immigration visas. We're talking about all immigrant visas from these 75 countries. This is significant because just last year, in August, the White House came out with the policy of revamping the public charge rule. So I did a detailed video talking about it. I'm going to shorten it really quick right here. Essentially, in the past, they're just purely looking at your finances and you individually. Okay, do you have a job? Do you have enough money in your bank account to support the essential minimum wage? Do you have a joint sponsor that are vouching for you? You do? Great. Very little cases gets denied in the United States. Very little cases get denied worldwide on the public charge rule. This administration's perspective is that is not true. That cannot be true. And since the first administration, first term of Trump, they wanted to enforce the public charge and deny a lot of people because they think a lot of people are too poor to come and live in the United States. And then since last year, the new memo went out, and I did an in-depth video, essentially more than just looking at your income, they look at your education, they look at your family ties, they look at what other people do. So, for example, if your children are using benefits, well, then the interpretation and the inference is, well, you must not be rich enough to even support your kids, and they need benefits. Therefore, you are going to be a debt to U.S. It's still always forward-looking. They look into the past to determine whether or not within the next year, 2 years, 3 years, you will be wealthy enough to sustain yourself. And so, yes, maybe you have a family member that is willing to support you, and maybe they have just barely enough in their bank account to support you. Well, you know what? That's just a factor because of your age. Maybe your health is going to deteriorate, and you don't have enough finances, and you probably cannot rely on them. So their finances not enough. Therefore, your case is going to be denied. That's what they're focusing on already, and now they're starting specifically with these 75 countries canceling all immigrant visas, whether it's family or it's business. I'll take some questions right now before I go on.
Yeah, if someone is pending asylum, can they marry a U.S. citizen?
Yes, you can get married. Whether or not the court is willing to close your asylum case and move it to USCIS, or whether or not they would want to close your asylum case and adjudicate you in the asylum immigration court, that is up to the judge to determine. In our experience, we've seen both instances happen. However, your standard of proof suddenly shot up, right? Other people, when they get married to a U.S. citizen, potentially they get green card if it's based on a preponderance of the evidence, just 50-50. Is your marriage, 50% real, 50% fake? As long as you pass that mark, you're good. Because of the asylum application, now you have to prove by clear and convincing evidence. So just imagine your standard is up to like 95%. So everybody else provide 50 documents to prove their marriage is real. Be prepared to provide 100, right? That's the general idea. But your question is, can I get married? Yes, absolutely.
How can I expedite my I-130 on financial hardship ground?
It's really hard. So I haven't seen that been successful. So I don't have good advice. I wouldn't recommend actually doing it because it's difficult. And if it's a financial ground, that might lead you to a 45 denial, right? Your adjustment of status or consular denial, because that's the whole thing we're talking about, public charge.
Is K1 under the pause 2? My fiance is in one of the 75 countries.
Okay. Great question. I think so. Reason being, K1, they categorize it under immigrant visa. Is it an immigrant visa? Like you're not getting a green card, you're just flying into the country, and then you're getting married, and then you're filing with USCIS. But I have a strong feeling that that will be paused.
Can ICE detain you at the airport if I have a real ID with work permit and I travel to another state?
So ICE can detain anyone, including U.S. citizens, because they want to check whether or not you're legal here. Your question might be, is ICE showing up at airports? And will they detain you if you show them a real ID? Real ID is not sufficient for them to determine your immigrant status, right? And so they could if they really want to. We haven't seen that much of it. What we have seen, which is already scary enough, is TSA and CBP agents asking, which, if it's a domestic airline, what are they doing even at the airport? But we have seen people get cornered and ask for their documentation. And we had a client pretty much was ready to book it, but at least they weren't detained, and then we got them the green card afterwards.
Is I-730 still going to be approved, or is that on pause or hold as well?
I actually don't know. Yeah, I don't know about 730.
My husband is about to complete his 10-year bar in Mexico. Got the bar in 2017 in Mexico. I need to know, what is next? What's the next step?
You file for whatever you need to file, right? Whether it's immigrant petition, non-immigrant petition, then you go through the consulate process. This 75 country ban does not affect, him. But then they go through the consulate process, and if it gets approved, then they get the visa, non-immigrant or immigrant, and then they come to the U.S.
How about asylum granted and filed the green card if you're Somali?
I believe Somali is on the 19 country, right?
Mm-hmm.
And if it is, then all benefits have been paused. So you filed it, it's pending, it's in a box. Nobody's going to adjudicate it. Nobody's going to I mean, you know what? It's fair to say they could deny it if they want to, but in our experience, having seen this over the years, they're just not adjudicating it, which to some people might be a good thing, right? Because let's say you know your case is going to get denied because it's weak for whatever reason. It's just pending. And so you're not going to get denial, so therefore you're not going to be deported.
What can you do to get citizenship if you're in that 75 banned countries list?
The 75 country list bans you from getting an immigrant visa to come to the US. And I guess now we're going back to the 75 country, right? So let me answer this question specifically. The 75 country ban bans immigrant visas from consulates. So what are the loopholes? What are things that you can do? You can get a non-immigrant visa, come to the United States, and then file for your immigrant adjustment of status here in the United States. So for example, let's say your parents petitioned you, you have a green card case pending with the consulate, now they're not issuing it. You even passed the interview for some reason. If you can get a non-immigrant visa, fly to the United States, you can file for adjustment of status and you can get a green card through that way. That's one method. You might be asking, if I already have an immigrant petition, how can I get a non-immigrant petition? I have immigrant intent. There are certain non-immigrant visas that allow for immigrant intent, generally 2 and maybe 3. The 2, the H-1B, right, H visas, and the L visas. If you're an international executive, then those 2, you can have immigrant intent. And so just because you have an I-130 approved, just because you have an I-140 approved with immigrant intent, you can still get those 2, come to the United States, and then file for adjustment. That's one method. And once you file for adjustment, you get the green card and you fulfill your green card status, then you can apply for citizenship, right? This 75 country ban does not ban citizenship. The 19 country ban bans citizenship because that's a benefit. But 75 country is purely just immigration and just basically focused on the public charge, whether or not you're wealthy enough. Now, you could always apply for a national interest exception. You can make good arguments, and in my experience, consulates will adjudicate those as well. They're going to issue new memos to be more clear about it. But a long about way is to use the visa to come into the United States. If you already have a visa, that's still valid. The 75 country ban is not a travel ban, so you could still potentially come to the U.S. You have to convince the customs officer that you're coming in, and then once you come in, then later on you could potentially adjust status. So that's one other method. Now, for a lot of our clients, right, who are part of the 75 country, you will be surprised. Most of them actually are dual nationals, right? And sometimes some people even have 3 nationalities. And so if you have 3 nationalities, the 75 country ban is purely banning those countries. You could use your other nationality with another visa to enter the United States as well, right? So, for example, Grenada is famous for selling their passports, selling their nationalities. A lot of people from Grenada, they actually have multiple passports, and so the 75 country ban only bans people with only those passports. And now that's why it's going to tie into the success story we're going to talk about later on, which is you can use the H-1B. And now the H-1B requires a 100,000 fee. So now you're starting to see the pieces come together. Trump created the H-1B 100,000 fee. If you want the H-1B from overseas, great, pay 100,000 to our government, and then you come work for 7 years, and you have immigrant intent. That's okay. Well, we're going to ban all these countries from receiving immigrant visas. The only way into the United States, if you really want your green card, now you could go through the H-1B process. Paid 100,000 fee. So, and later on, our success story is about somebody who didn't pay the 100,000 fee because they were in the US. They created a startup, and so now they could do it. H-1B couldn't do that in the past. It was much more difficult. They lowered the standard, much more easier. We're going to go through all the details of it so you can see and compare your own case. But that becomes suddenly a method if you want your case to be faster.
We're getting a lot of questions about K-1. So you think it will be paused?
I think so. I definitely think so. I mean, K-1's already taking an extraordinary amount of time. And in my experience, having seen a lot of the K-1s, K-1, they categorize a lot of times, it's the immigrant visa unit that is adjudicating K-1s. So this is a immigrant visa ban, so I feel like they're going to adjudicate it. Now, if they do issue it, great, right? That will be wonderful. You come in as a non-immigrant, you then you can file for adjustment of status. This 75 country ban won't stop you from filing for adjustment of status, but I just, from everything that I'm seeing, right, the consulates focusing on the public charge, not allowing people to come to the U.S. to become a benefit, they are that is squarely within what they're focusing on. Now, let's say the consulates do allow the K-1 visas to go through the non-immigrant channel to get the non-immigrant visa to come to the United States. They might still make you pay the 15,000 bond, right? So that came out also last year, where, oh, if you're going to come in and you promise that you're going to leave the United States, you need to pay a 15,000 bond. But that also doesn't quite make sense in the K-1 category, because the K-1 category, you're coming in as a fiance to get married and you're not planning on leaving. So it doesn't make sense for you to pay that 15,000. So sort of a catch-22. We definitely need more guidance on that. But if you're asking me personally, my bet is the K-1 will be stopped.
On this public charge issue,
Yes.
green card holder, can they still apply for a spouse visa if the green card holder themselves took Obamacare, not any benefits?
Green card holder who is the petitioner got benefits, and now petitioning the beneficiary who is the foreigner, and now the foreigner, I'm assuming, is not part of the 75 countries, because you'll be banned, right? You're somewhere else, whether a different consulate overseas, India, China, anywhere else, or you're in the United States filing for adjustment. Now they're supposed to look at beneficiary. Let me look at your education level. Let me look at your health level. Let me look at your finances, your career, your prospects. Look at everything. And on top of that, you are married to this lawful permanent resident. Look at their finances. They are obviously sponsoring you. We're looking at their tax returns and their income. Holistically, what are the chances within 1 year, 2 years, you're gonna, become homeless, fall into debt? They're gonna look at everything. So if your question is, will they look at the lawful permanent resident's income using Obamacare? Yes, of course, it becomes a factor now. And that's the scary thing about the new public charge rule. It is case by case, it is wide, it is not a red line, very, very specific, only looking at key requirements, right? In the past, we're talking about the past like 10, 15 years, public charge is purely, almost purely looking at, did you take federal government money for a sustained amount of time, right? If you take federal money for a little bit, that was even excused. But did you take federal money for a sustained amount of time? If you use states' money, if you use charity, if you use other people's like gifts and charity donations, all that is fine. That's not the government's money. But if you use the federal money, then it becomes a problem. Now, even using other people's money, they're gonna really scrutinize you.
If your spouse is already in the U.S. on an active visa and I petition for him, are we going to get denied?
If you're part of the 75 country, you can file for adjustment of status. So you don't have to go back to the consulate. And here's a key point. A lot of people, they're in the United States on a H-1B visa, F-1 visa. They have an immigrant visa abroad appointment, and normally a lot of people will fly back to do the visa appointment and get a visa and then come back to the US. And in all the application filings, they all said we're going to do it abroad. If you're part of that 75 country, the first thing you need to do right now is to do a transfer. Stop the consulate processing, transfer it back to USCIS, and then file for adjustment of status, because you can still do that in the US as of right now. Now, if you do it in the US, you should still prepare for the public charge analysis, right? But it is much easier to do in the US as opposed to this indefinite pause outside.
I've been waiting in line for their 2 agents to get back to me after my expedite follow-up today, and the agent told me I'm still in line. It's been over a month. Is this because my country is still on the list? What should I do next?
Not quite sure what that means. Agent still in line. I mean, if there's a ban, there's really not much you can do other than potentially filing for a national interest exception.
I see. So once payment is taken after the files is received, is my paperwork now at the NBC?
Yes, if you made a payment, it's with the NVC, National Visa Center, and then National Visa Center, once they complete it, they'll transfer it to the consulate. If you're part of the 75 country, well, that's where it's going to stop. After the interview, they could still do interviews, right? So you can still go in, prepare everything could get approved, and now they're just waiting. Well, we have a ban, we have to wait, and then once it's issued, then you can get it.
I'm a businessman from Pakistan. Will this visa pause affect E2 visas?
The 75 country does not pause non-immigrant visas. So you can get the E2, come to the US, and then if you have an opportunity to get a green card through marriage, through family, through another petition, then you can adjust status in the US as of right now.
Is it better to apply for E2 within the US or through the embassy abroad?
Almost everyone applies to the embassy abroad. There are clients of mine that do change of status to get an E2 in the US, build up the company, and once you're fully confident, then you leave the US to get the visa. But that applies to very, very select few individuals. Most people prepare well, they'll just go to the consulate, get the visa, and come.
I have a K1 approval. I'm waiting for NVC. They are part of the 75 countries. Is this going to affect my case?
In my opinion, it will.
Why would an embassy be holding the passport after requesting it from the US? It's been 3 to 4 weeks.
It could be any sort of reason they want to do background check.
Do you still think it's a good idea to go to interview appointments after the 21st?
In what context? Is it
So yes, from the 75 country. And I believe DOS did say you can go.
Yes, so still go because there's going to be a huge rush after this indefinite ban gets lifted. Potentially a year, 2 years, 3 years, 4 years from now, right? Who knows when? But as long as you're still going, everything gets checked out and you get approved, maybe later on, everything checks out, you just directly get the visa in the mail.
And yeah, we're getting some questions on who this does not apply to. So like if you're in the US already, can I renew my green card?
Right.
Do a citizenship, stuff like that.
So the 75 country ban only applies to immigrant visas, meaning a visa into your passport, coming to the United States to get a green card. So it does not apply to non-immigrant visas, B1, B2 tourist visas, F1 international student visas, L1, O1, all the other non-immigrant visas. It does not apply to people in the United States transferring, changing, adjusting status to get a green card. And it doesn't apply to dual nationals, right? So if you are from the 75 country, but you are also a French national, you could still use your French national to go to the French embassy and get a visa, obviously, right? So it's much more expansive.
So I know there hasn't been an end date, but what's your best guess on how long this will last?
My best guess is that this will last 3 years. I think it will carry out for the next 3 years. In my opinion, I think it will be expanded as well, not just the 75 countries. They might tag along another 50 plus. Continuing this train of thought, they're adjudicating public charge. Once this is reviewed and the system is created, they're going to apply that to 200, 300, all other countries that they want to apply to. Not a full-on ban, but suddenly every immigrant visa interview becomes that much harder because they have to go through a super in-depth public charge analysis. And then after all the consulates, or while all the consulates are increasing this type of scrutiny, and a lot of immigrant visas are being denied all around the world, when they're doing adjustment of status, they will also implement this higher scrutiny. That's my prediction. And the biggest consequence of it is that it will free up a lot of visa categories and it will flow into the employment visa category, specifically EB1 and EB2 for India, China, and some of the other countries that have a backlog. That is the direct and most consequential effect going into the next 3 years. And that relates to the Trump Gold Card that he wants to push. He launched it. A lot of people want to do it. He has received a lot of feedback, so far as we can tell. But the biggest downside and the biggest drawback to it is, well, there's a visa backlog on the EB1 and EB2 category, which he is trying to use. So why would you spend $1 million and you have to wait compared to EB5? You don't have to wait and you can directly get it. So that is the biggest limiting factor. How can he speed up the EB1 and EB2 processing time with the priority date? This is the method, by completely slowing down and canceling all visa categories in the family department from all around the world. All that visa suddenly pours over into the business, and it allows him to basically sell as many Trump gold cards as he wants. That is my conspiracy theory. I just want to label it as that. There's nobody who has, I mean, I don't know if anybody else has said it, but there's no official primary documents to say that is the intent. But these are the pieces. He created the H-1B with a 100,000 fee. He created the Trump card with the drawback being that there's a priority date, and now he created the public charge, stopping all immigrant visa categories. The visa categories will flow back into the business category, and then it will solve the EB1 and EB2 backlog. I don't know. You tell me if that's his intent or not, but at least that is the consequence.
Will this affect the 75 country thing, affect F1 OPT?
If you are an F1 international student in the United States, you're not getting an immigrant visa and you are getting OPT, so that won't affect you. However, just be warned, USCIS is going to crack down hard on OPT, so that is a separate story.
My husband is an LPR. We owe taxes but want to apply for citizenship.
Okay. You should pay off your taxes and then apply for citizenship. We have seen USCIS deny cases because of back taxes that are owed.
What about citizenship with child support, like a $30,000 in child support owed?
That goes into good moral character analysis. You can try to overcome it. Usually it's a little bit more difficult. In my experience, it is probably better to go on credit card debt than it is to have any back taxes to the government, to child support, anything that's related with other type of criminality, right? If you just owe money to the credit card company or a loan shark, that is just a civil matter between you and another company. But if it's against the government, if it's against another child and a human being, that becomes suddenly potential criminal. And so I highly recommend, if you have any of these and you really want to become a citizen so you get all the citizenship privileges, you might have to go in a little bit of debt, but on a private front.
So if someone from the 75 countries is applying to get citizenship and they got denied, is that application paused?
If you're part of the 75 country and you apply for citizenship, and then your citizenship is denied by USCIS, and then what's the question?
Is it paused now?
It is not paused because you can apply for citizenship again, right? This is the 75 country ban does not ban you from applying for citizenship. Yeah, it is because citizenship is adjudicated and approved by USCIS, which is in the United States, not at the consulates.
I'm a green card holder, wanting to become a citizenship. I've gotten insurance through Marketplace. Is this an issue?
You want to apply for citizenship?
Mm-hmm.
Oh, no, I don't think the public charge rule. I'm assuming that's what you're talking about. That mainly bans people who want to get green cards, right? So if you already have a green card and you're applying for citizenship, public charge rule doesn't really apply to you as much.
Can you still apply for I-130 for your spouse or a sibling? Two different cases, two different questions. If they are in these 75 countries.
So the answer is yes. You can apply for the I-130 with USCIS. It will go through the normal processing, a year, 2 years, or longer. Once it gets approved, you could go through the National Visa Center process and submit everything, and then you could go to the consulate and still get the interview and go through everything. The only thing that won't happen is you won't get that visa in your passport to fly into the US to get the actual green card. So you might be asking, then why do all of this if I won't get it in the end? Well, this is an indefinite pause. It might restart, in my opinion, 3 years from now, 4 years from now. And a normal immigrant petition could take 1, 2, 3, 4 years anyways. So might as well still start and see what happens. And also, Maybe you go through the I-130 process to petition your spouse, your children, whatever. Once it gets approved, they can potentially come to the US and then do adjustment of status here, right? So you should still start the process if you haven't started. If you already start the process, maybe now you need a pivot, right? So a lot of these plans is to force people to get a different visa to come to the US to do adjustment of status in the US. So now suddenly all these other visa categories, whether it's F1 student visa to become an international student, whether it is to get a tourist visa, whether it is to get an H-1B work visa, all that becomes suddenly increasing valuable because that allows you to come to the US, bypass the consulate immigrant visa interview, and then adjust status if you qualify.
Interesting. So is it true that if you marry an asylee, they will be sent back home until they receive a green card?
I don't know because we don't do asylum cases. If you marry a asylee, well, I'm assuming you're saying they are in the asylum process. And if the asylum process is successful and it goes through, they will get the green card. So they don't have to go back to their home country. If you are a US citizen and you marry them, you can also help them adjust in court or with USCIS, and they can get a green card so they don't have to go back to their home country. So now, if the asylum application gets denied, if your marriage petition gets denied, then they're out of status, then they get deported. Then, you might have to apply for a waiver or something. But yeah, I think that's the context of the question.
Any updates on DACA?
Nope, sorry. Haven't heard anything on updates of DACA, but we're still paying attention. Personally, I don't think there will be a big update on DACA in the next 1, 2, 3 years. Being very pessimistic here. As far as like any major groundbreaking changes in a positive front, I'm just crossing my fingers so that it doesn't go downhill. That's like the main thing that I'm trying to be aware of.
Can you apply for citizenship with a misdemeanor, either expunged or not expunged?
Expungement doesn't matter in immigration law. It's a plus point, but it is not like a defining thing. But yes, you could definitely still get your citizenship even if you have a misdemeanor.
What about AOS through marriage? You owe taxes, but you're currently making payments, like you're on a payment plan. Is that an issue for citizenship?
In my experience, officers don't like approving citizenship if you still have taxes that are owed. Now, maybe if the funds are so big and you are so wealthy and it is an agreement and they see that, okay, this is not a problem, they could approve it, but it takes an extraordinary amount of discretion for the officer. Generally, if it's a small amount, they just want you to pay it off, right? By small amount, meaning generally anything under 100,000, right? People have large debts, home debts, car debts, credit card debts. Why can't you just go in debt and just pay it off, right? And so now, if you owe government a couple million, but you are a multimillionaire, maybe for finance reasons you can explain why this is the only thing that makes sense. Maybe they can make a discretionary call, but that's based on my experience.
As a U.S. citizen, can you file for your parents to come to the U.S. if you're in one of those 75 countries? Like your parents are...
So you can invite them to come. Hopefully they could get a tourist visa. They could get some sort of other visa to visit because it's an immigrant ban. So if you're petitioning them, it's going to be stopped, right? But if it's just an invitation and they can get a tourist visa, then they can visit. And once they visit, if for whatever reason they need to stay here and plans have changed, you want to file adjustment of status, then you can file adjustment of status here.
Right. And can you say a little bit about applying for immigrant status after you come on like a non-immigrant, like a B1 or something where you have non-immigrant intent?
Right. So there are only 2.5 immigrant visas. There's only 2.5 non-immigrant visas that allow for immigrant intent, which means you can loudly and proudly declare, I want to get a green card while having this visa. So it's the H-1B visa, it's the L-1 visa, and the 0.5 is the O visa, because sometimes it's allowed, sometimes it's not allowed. It's complicated. All the other visas, tourist visa, student visa, you technically shouldn't have immigrant intent. So the way around that and the way to really clarify is when you talk to the officer, you say, this trip, this time, right now, I don't have immigrant intent. Maybe 5 years from now, maybe 10 years from now, maybe in the background there is, but right now, I'm just here for Disneyland. I'm just here for this trip, and I have a return ticket, I have a hotel, and everything. If the officer believes you, great. You have non-immigrant intent, you came in. But now, let's say within 90 days, or even after 90 days, suddenly your plans change and you have immigrant intent. Now you need to convince the immigration officer at USCIS that you did not lie, right? You came in without immigrant intent. Suddenly you have immigrant intent. Well, did you have immigrant intent before and you suddenly lied to the officer? That becomes a big deal. And we're going to see that more and more. Ever since last year, we started seeing a lot of it. And it becomes purely discretionary now to the officer. So you really have to document that well. Past 10, 15 years, it wasn't scrutinized as hard. This year, it's going to be scrutinized a lot harder, especially if you're part of the 75 countries, because it's just too obvious. You cannot get an immigrant visa. So you came as a tourist. And then you brought like all your family mementos, and then you didn't have a return ticket, and then you stayed here for 9 days and you filed for adjustment status. Like, it's clearly you had immigrant intent beforehand, right? So you definitely want to clearly articulate it both to the customs officer and then later on to the USCIS officer.
Now, what about TPS? Have you heard anything about TPS?
No, we don't do a lot of TPS at the firm. I wish we could do more. If you know any nonprofits that do a lot of it, our nonprofit arm, Making Immigration Better, we will partner with other TPS nonprofits.
I'm married, a Mexican American. Can I become a Mexican citizen even if I'm a citizen from Venezuela?
I believe you can. Provided that the Mexican American has a Mexican passport who can petition you in Mexico. And we have seen people do that. So, yeah.
I'm here on an F1. My employer filed for EB3. I'm from one of these 75 countries. Does that affect my adjustment?
It does not affect your adjustment of status. But if you end up somehow needing to go back to the country and do a consular processing, then it will affect you. So you're good. You're in the U.S. A lot of people who are part of these 75 countries, a lot of them are actually here in the U.S. already, right? More than half, actually. And so I know there's a lot of news that says, like, oh, these immigrant visas are going to be transferred over to India. It's wrong. It's incorrect. Because a lot of people will just use their dual nationality and then come into the U.S. and then file adjustment of status. So it will block a significant amount of people, but it's not going to block like 300,000 visas, and then it will go into the employment pool, right?
Will I still be able to get a date for my interview during this pause?
Yes.
I'm a citizen. What's the easiest way to bring my fiance wife to be to the United States, assuming she is one of these 75 countries?
That's really hard. You might look into a third country national, right? So if she has another passport, that might be a lot easier. If you can help her get a non-immigrant visa, that might be a lot easier. For example, maybe she wants to study dance. I don't know, right? Get into a really good school, F1 student visa, come to the US, then get married. Maybe that is a much better idea. Or maybe she loves cooking. Help her start a cooking academy, a school, do the H-1B spill, self-sponsor, bypass the immigrant visa. So easiest and fastest is now not something that is easily attainable if you're part of these 75 countries.
Does military parole in place still remain?
Yes, we still see a lot of these cases get approved.
I already filed my citizenship. Biometrics are done, but I'm part of one of these 75 countries. What happens next?
You wait and you go to an interview, and if all things go well, you pass and you get a green card. You get your citizenship.
I have applied and gotten approved already. So what happens in these 75 countries?
You wait, right? Because if your visa is already done, they haven't issued the visa yet. They cannot issue it now. They have to review everything. If you don't have another nationality, to come into the United States, if you don't have another non-immigrant visa that's still valid to come into the United States, and if the only thing you could do is wait, then the only thing you can do next is to apply for a national interest exception, right? Argue that the public charge rule totally doesn't apply to you and that you are critically important to the United States. Write the brief, argue it, and potentially if that passes, then you can come.
Right, yeah. So when the Department of State released their clarification yesterday, they didn't mention anything about the national interest, but then the Guardian said they saw a cable that said there was going to be one. So,
and in all the previous bans like this over the years, whether it's COVID, whether it's Afghanistan, whether it's Israel, even if official memos don't come out, you could always apply, and it's a discretionary basis on the officer.
What happens if IR1 visa is approved but not issued by the 21st?
Then you're in that waiting game.
Just until it is. Should we apply for residency for parents at this time?
Yes, if that's what you want, and you're in the U.S.
I'm afraid to file with everything that's happening. I don't have a criminal record or any deportation. Is it safe?
Hundreds of thousands of people across this country are getting cases approved. So, you know, if you're standing there, you're seeing throngs and throngs of people getting visas, getting green cards, getting citizenships. If you have good case, you should totally apply, right? Don't let fear paralyze you.
Okay, I want to talk about our H-1B success story. This is really relevant because with these immigrant bans, non-immigrant visas like H-1B are all the more important.
Right. So today's success story is about the H-1B self-petition. It is when you start your own company and you petition yourself and say, this company needs a specialty worker. This specialty worker comes in, works for a company that is purely startup, just freshly incorporated, freshly funded with no employees. Oh, thank you. Appreciate it. And you're the one who worked on this H-1B, right?
I did.
So let me do a quick interview.
Can you introduce yourself as well?
What's your name?
Hi, my name is Joanna Lee, and I'm currently a legal intern here.
And this was a hard case.
It was.
How did you feel when you were working on this case and, you know, you and Grace toiling into the night, fighting through it? What were you feeling? What were you thinking?
Well, it was difficult to begin with just because it was our firm's first ever H-1B self-petition, so there weren't no references or examples for me to look at, but it required a lot of research on our end just to see what the industry norm is, what the standards are. And another difficult part I felt was H-1B self-petition in general, you're not working with many documents. You're starting from scratch, right? So even things like building the website, finding an office space, that's all the steps that we need to do to build this case. So it was kind of new and interesting on my end because I've never worked on stuff like that before, trying to help a client navigate how do they draft an operating agreement. That was all new to me. So on my end, I did a lot of research figuring out what the standard is and building that up so we could have a strong case. Another challenge was that we were on a time crunch. So it was a balance between, are we going to put more time and effort right now into the initial filing to make it the strongest possible? Or are we going to anticipate an RFE, have more time on the RFE, less time right now? So it's that balance between which direction do we choose when we don't even have many documents to work with, which is why ultimately I think we decided to build a stronger initial case just because we don't have the luxury of having all these documents to really prove that our business has so much potential, so much growth, so much revenue. So that's kind of the direction that we headed in.
When I was looking at this case, everything looked weak, doesn't it? It's a fresh startup. There is no fancy office. There wasn't a lot of clients. I mean, we'll go into a little bit of details about this business. Again, fresh startup. He had the experience as a business developer, right? He worked for different companies in the past as a business developer. He knows how to do social media. He knows how to do marketing. And now he's a consulting company trying to help other businesses be better and to do more business development. But his own business development isn't even that strong. So how did we make the argument? How did we argue? And how did he get the funding? And what is he going to do? I mean, all of this was on you, was on Grace and the client, and how much time did you guys have to make it happen?
I would say we had a couple months, maybe 4 months-ish. Yeah, it was difficult just because we can't really do anything to start the business, right? We're not signing clients right off the bat. We're not out there promoting ourselves. We're starting from scratch. So how do we show client interest when we have nothing to prove our work other than his previous past experience? So the difficult part was trying to really gather all that client interest. We had a lot of letters from potential clients saying, once the business starts, I am interested. We had a couple clients put down payments on saying, this is my advance payment for when you guys start the business, which I believe really made our case stronger because we're saying, here, once, this is approved, that we have people already lining up. There's already interest. It's not like we're starting from scratch saying that there's no one interested right now. No, we already have all these people. So once we start, we'll be even more successful, even more profitable. So I think that really gave us a leg up. He had a great resume, great experience, which also helped contribute to the case. His education was great. He was clearly qualified, but just translating that, saying that he's so qualified. That's why he's creating a business, because he has all this knowledge and expertise, not in just social media, but even in consulting and just growing a business from scratch. Like, he is the most qualified of anyone to build a business like this, and he wants to help his community and give back to business owners. So that was kind of the pathway and strategy that we strategized in order to build his case stronger.
Right, because he had an MBA, he had a long career history working at social media, marketing, business development itself, and then creating this business development consultancy. Now, salary is always going to be very difficult as well. So we got a wage level 3 salary, right? And then that was the exact amount that we invested. Right, so salary was around 100,000, 110, 120,000. That's the exact amount he self-funded into this business, proving that he has the ability to pay himself at least that minimum salary. And then all the income from the customers is able to just run the business, and that he will eventually transition within 18 months from just doing everything as a founder to now just focusing on his specialty, because we cannot say he's going to be just the founder mode, right? That's the difference between the H-1B self-petition and an E-2. E-2, you are the founder and you want everybody else to do it. The H-1B is the reverse. I'm the founder specialty worker. I'm going to, create it, and I'm going to hire an operations person, and then I'm going to do what I'm really good at doing. Not easy. Props to you. Thank you for the tea. And very proud of you.
Thank you.
You did well. Amazing. So anyways, we're going to see a lot more of that, because now this becomes an option, right? So let's say you are abroad. Let's say you are, in one of these countries that are banned, or you're in another country and you need a visa to come into the United States to file for adjustment of status. Well, guess what? Before, you didn't have any options. Now you can do the H-1B. Before, doing a self-sponsored H-1B was incredibly hard. But now the bar has been lowered. The only thing is the price tag just went up. So now there's a 100,000 price tag. Very few people are doing the 100,000 price tag, from what I've heard, from what I've seen. But a lot of interest is in the Trump card. So now this public charge ban on 75 countries, and including making it much more difficult on immigrant visas worldwide, is going to push all the immigrant visa category, all the unused quota, into the business world and into specifically EB1, EB2 categories of all the people who have backlogs, which is mainly, again, China, India, and then eventually some of the other countries that will have more and more. So that's a success story that we want to share with you today. We still have a little bit of time left. We'll answer more questions, and then we'll close out.
My fiance is Burmese. Already the I-129 route is closed. Is there any hope for us to get her here?
H-1B visa, non-immigrant visa, still open, right? Come in. If it's fiance, then marry, then get adjustment of status, right? So just like what I was saying earlier, this policy clamps down on immigrant visas, and in my prediction, it might last for 3 years. So it's going to force everybody to go through non-immigrant visas. Now, if she's in a dating relationship with you, it's going to be hard to get a tourist visa. It's going to be extremely hard to get an F1 international student visa if she is not a scholar and within the age bracket of a student. So if you can't do B1, B2 tours, you can't do F1. One of the only options left, H1B or O1, or if she has a company, then potentially an L1. So that's the unfortunate circumstance this administration is making. They are essentially clamping down on family-based immigration. You can't get visas so easily. And even, like, for example, a lot of people who have EB2, EB3 approvals, right? You're waiting for a green card overseas. Well, guess what? Now, immigrant visa is not going to be issued you overseas. You have to get an L1 first. You have to get an H1 first. And, you know, if you have to do H1 and you never had one before, you need to pay the 100,000 fee. So it is a big change, and I don't foresee it letting up. I foresee this being just the first step.
If someone applied for T visa but received a notice from USCIS saying that the case was not bona fide and will be in review for additional evidence, including EAD document, including the EAD request. Thoughts? Sorry, yeah.
Again?
If someone applied for a T visa, but they got a notice from USCIS saying the case was not bona fide and will be in review for additional evidence, including the EAD request.
Okay.
Thoughts?
Well, prepare for the request for evidence. USCIS gets things wrong all the time. Again, you know, they're just looking at a few paperwork and they're working with statistics. They only have like 10, 20 minutes. So when they issue you a request for evidence, you have all the time in the world to prepare a super strong case to respond to it. So I wouldn't worry too much about it. Now, get help, get a lot of help to prepare it. I don't mean like necessarily attorney help, but preparing the documents to explain it, right? Proving that the trafficking existed. Get testimony, get letters, swear, we saw a case do this that was very novel. Do a, what's that called? A polygraph test. You know, they don't believe you're telling the truth. Pay for a polygraph test, do a transcript, send it in. Like, I've not only notarized, I not only signed under perjury, I did a polygraph test. How can I lie, right? So do everything you can to prove to the officer who cannot see you, hear you, they're just looking at your documents, and convince them that your case is bona fide.
I applied for I-130, but I just get the receipt. Do I have to do another application after that?
In order to get a green card, yes. I-130 just proves that your relationship is real. Then the green card is proving that you did a background check and that you deserve a green card.
Is I-130 harder than the next step, or is that the easier of the two?
Most of the time, I-130 is significantly easier than the 45, significantly. I-130 typically is just proving that the relationship exists. So if it's a marriage-based case, your marriage exists, providing pictures and documents. But 45 is your medical, your criminal history, your wealth. It's everything else. Where you live, your whole life, right?
Can a LPR who's already in the U.S. travel out of the country if they're in one of these 75 countries? From one of these 75 countries?
Yes. Just make sure you're not part of the 19 countries, right? So you can leave. You're just not, the 75 country ban is on new immigrant visas. So if you already have a green card, that's fine. If 5 days ago you just got a passport with a visa on it, you're fine. But if you just went to an interview and they didn't issue the visa yet, sorry, that stopped.
How long can a field office take to schedule an interview? And do you have any tips for that interview?
I have so many tips for interviews. Follow our channel. We're doing more and more videos on tips for interviews. If it's an N400 interview, we did a whole video on that already, so you can check that out. But for adjustment status interviews, we are going to release it. You could also check our new channel, the Making Immigration Better, on YouTube. We just did an interview with a consulate officer talking about all the tips. It's in Chinese, but we're going to release the English version very soon, probably next week.
If you had to boil it down to just a couple key tips for our audience now.
Yeah, okay. If I had to boil it down, know this. They have all the authority. Your fate is not predetermined. Convince them within a short amount of time. How to convince them? They're just a human being just like yourself. Don't leave anything ambiguous. That's a cultural difference. A lot of Eastern cultures like to keep things ambiguous because that's the wise thing to do. In the Western culture, if it's ambiguity, it leads to denials. So if I want to boil it down, eye contact, clear, convincing, don't leave anything ambiguous. Talk to them like they're a human being. They have interviewed thousands of people just like